attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the second Lawcast in a series discussing Rule 506 of Regulation D, including the difference between a traditional 506B offering and a 506C offering that allows for general solicitation and advertising. Both Rule 506B and C are promulgated under Section 4A2 of the Securities Act of 1933, and both preempt state law under the National Securities Market Improvement Act, or the NSMIA. As with all offerings that federally preempt state law, the states are still allowed to require a notice filing and a payment of a fee, and the offering is still subject to the state anti-fraud provisions. As such, the states maintain the authority to investigate and prosecute fraudulent offerings or transactions. A company may elect to complete either a 506B or 506C offering. Both offerings allow for an unlimited capital raise and for continuous offerings. Securities issued in any Rule 506 offering are restricted under Rule 144. The historical Rule 506, which is now 506B, allows for offers and sales to an unlimited number of accredited investors and up to 35 unaccredited investors, provided that if any unaccredited investors are included in the offering, certain delineated disclosures, including an audited balance sheet and financial statements, are required to be provided to all potential investors. Under Rule 506B, a company can rely on an investor's representation as to whether they are accredited or not, which is usually accomplished by checking a box in a subscription agreement or questionnaire. Rule 506B prohibits the use of any general solicitation or advertising associated with the offering. Rule 506C, which was enacted into law effective September 23, 2013, allows for general solicitation and advertising. However, all sales of securities are strictly limited to accredited investors, and the company has an added obligation to take steps to verify accredited status of that investor. The investor cannot simply check a box or self-verify. Rule 506 allows for any and all forms of advertising and solicitation subject only to the anti-fraud provisions. Since a company cannot control who sees its advertisements or whether the viewer is accredited or sophisticated, advertisements should contain a disclosure stating that the offering is only available to accredited investors. A gating question is whether a company is engaging in general solicitation or advertising for purposes of determining whether they are utilizing Rule 506B or C, and whether they have to take extra steps to verify accredited status and limit the offering to accredited investors. SEC interpretations and case law have established the principle that where there is a pre-existing substantive relationship with offerees, offers will not be deemed to have been made by general solicitation and advertising. In the last Lawcast in this series, I discussed conventions and venture fairs, and in particular where there may be an established relationship even when giving a presentation at such a convention or a venture fair. In the next Lawcast in this series, I will continue with a discussion of the concept of a pre-existing substantive relationship. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's Lawcast, please visit securitieslawblog.com or lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.